they should have a self-regulation to that. They have to remove the content, otherwise they are liable for civil and both criminal remedies. So this is a huge disruption happening now. And recently, EU mentioned about the EU's single market directives. Two new things they try to introduce. It's nothing but a clarification of the existing EU directives on the internet and digital environment. To remove the one most controversial was the link tag civil issue they rise in Article 11. Later it is Article 15 now. So whether linking of any YouTube song or any news item is legal or illegal, this is what covered under this. Two new things that comes about the link of newspaper clarifications. So it was explained that the Google or the other platforms are to be held responsible. Any illegal, unauthorized content is provided link, but not the person, the Facebook user or Facebook account holder held responsible for that. And then next comes the filtering or meme ban issues. So meme ban was the big issue was talked about. Finally, it was explained that the Article 13, then now it is Article 17. There is no meme ban. You know that the moment you open your WhatsApp, the moment you open your social media website like Facebook or Twitter, you see so many memes. The memes are two kinds. One is the video content, small clips of a film used to criticize something or parody or a pastiche. So in a funny manner, parody or criticism of something, either memes, photographs of film actors that the films use. So if you look at the rights given to the film producer, the author, as per the Copyright Act, Section 2U says, author of the film is producer because he takes the responsibility to shoot a film and complete a film. So even taking a small photograph, a screenshot of a film and commercializing it is illegal. It's a copyright infringement. Then how you are allowed to do a meme of a photo of a film? Let us say Gabbar Singh in the Sholay film that is being used, or any other film photo. So copyright exception given the fair dealing, section 52(1)(a), fair dealing for criticism and review, that allows you to do that because you are innovating and then trying to create new original content by indulging in criticism, review, and parody. So that is allowed, is not infringement of copyright. That's what explained in the EU single direct copyright. So creation of a meme, both using a photo or a small film clip, is not illegal, and sharing such thing is not illegal over internet. So internet meme has become a norm now. It gives a lot of relief to us, to our stress life. When you see a meme that you simply start chuckling and smiling. So that's what happens. So this is an explanation I wanted to tell, because many times people ask. So when I'm talking about the copyright exceptions limitation, whether the exceptions provided in the Berne Convention for the physical copies extendable to the digital copies of the online environment through the WIPO Copyright Treaty and WIPO Performances and Phonograms Treaty. Yes. If you look at the Article 10, which talks about limitations and exceptions to the copyright in the WIPO Copyright Treaty, it talks about the same language which TRIPS Article 13 says that copyright exceptions shall be available in certain cases. Certain cases means, for example, education purposes, like this online instruction purposes. It is a special case which does not conflict with the economic exploitation of the work. So let us say that I'm reading 10 books and trying to communicate the knowledge out of those 10 books about international copyright system, about various conventions or Indian law, and various examples and concepts and theories. So I'm not infringing a copyright. So any teacher is not infringing a copyright while explaining in the classroom, in the physical environment, or through online in this manner. Let us say what happens, I'm using a PowerPoint presentation and then giving you a lot of information, and then using photographs, using memes, and to explain various things. So only thing is I need to give a credit. I need to give you acknowledgement that from where I have taken, I'm using this for educational purposes. That's enough. So copyright exception, such an extent are allowed. So because I'm not commercializing this, I'm using this for instruction purposes, for education. So in the Delhi photocopy case, Delhi University versus Cambridge publisher versus Delhi University, and Rajeshwari photocopy shop at the Delhi School of Economics. Delhi High Court, Justice Rajiv Enlaw, in his single judgment, beautifully explains about the teaching. He said that I'm not dwelling into the online teaching. I'm restricting myself to the offline, the physical classroom teaching, but still, as per the provisions of copyright law, these are extendable to the internet environment as well, because the creation of postcards and supplying to the student, the preparation for the classroom teaching, that instructional purposes, that's what the terminology we use in any work means, is both used for internet, this kind of teaching or instruction, or in the physical classroom purposes. It is allowed to making such copies and making that available. And coming to the discussion about the case. This was challenged before the divisional bench, and again, the Justice Pradeep Nandrajog and others completely supported the arguments of Justice Rajiv Enlaw, that creation of course parks for the educational purposes is not infringement of copyright law. So that is very, very important. And then, and third one is the third test, apart from certain special cases which does not conflict with the commercial exploitation of the work, and then does not prejudice the interest of the author. So that comes, what is the prejudice of the author? It talks about, many experts talk about private and personal copy introduced, exception introduced in various municipal law. So if you look at the copyright law of India, we have also introduced private and personal exception. So for educational purpose, or even for your internet, you take a book and go to a photocopy shop, and photocopying for your personal or private use is not infringement of copyright. Right owner author can't be after your life with asking police to file an FIR against you and drag you to the police station. So that will not happen. And then question comes, what extent you photocopy? 99.99% out of 100, no one photocopy the entire 100% of the book. They photocopy only a portion of a book which is required for their educational purposes. And in one of the cases, that Manipal University case, court has said that even that thing happens. Both cover photocopy never happens, but even if it happens, this is legal under the private and personal copying, because it's not going to affect the physical sales of the book outside, because not mass copying is not happening, mass piracy is not happening. If one person indulging in that, most of the people do not indulge in such activity. Then this provision I was talking about, which allows copyright exception provided under the Berne Convention to the digital environment, the Article 10 of the WCT. And there is an agreed statement, below attached to the Article 10. So, what is the agreed statement? Agreed statement gives further clarification. It extends the law while explaining that article to which it belongs. So, what this agreed statement talks about, agreed statement gives an explanation that member states who have signed and ratified the treaty called the WIPO Copyright Treaty, which extended the copyright of the physical environment to the digital environment, from the Berne Convention to the online networks, physical environment to online networks, can devise new exceptions to address the issues pertaining to digital environment. So this is the new use happening, the new way of interacting to the students using various apps, meeting apps, and then giving online lectures. So it has become a norm during the lockdown. So this is a new exception. This is already allowed under the Indian Copyright Act. That's what I'm saying. So whether the reading of this agreed statement, which gives an explanation to the main article, is legal internationally or not. Yes, it is completely legal. How the treaty texts are interpreted, most of the teachers, law teachers listening to this talk may be aware about existence of Vienna Convention of Law of Treaties 1969, which gives general explanation to the treaties, existing treaties, also how treaties are negotiated, how the delegations devolve power from their national states and go to the negotiation and sit down and then negotiate, and what is the pacta sunt servanda. So pacta sunt servanda is a Latin term. Once treaty is negotiated and the new article is inserted and finalized in the treaty, you can't go back. So once you are agreed, you are given commitment. So performance of that contract has to happen. So in no way you can't oppose that. But there are some reservations also. Treaty can introduce reservations on a particular article because various socio-economic, technological developments in your particular country, it's not comparable to the developed nations which are negotiating and imposing such a treaty on you. If you fear that your industry will suffer, your people will suffer, your country will suffer, even the economy, the contribution of that particular industry to the your GDP will suffer, you may treat that particular article not a part of the treaty by introducing, by submitting an instrument of law explaining that that particular article, your country is not a member of a treaty, but other remaining article only you are agreeing. That extent you are member of treaty. That is allowed as per the concept of reservation. But in future, anytime you can come back once your economic condition and technological condition in your country has improved, you have become a match to the developed nations, and then you can always withdraw that instrument and de-recognizing that reservation, and you can become a party to the 100% of the treaty. Then coming to the interpretation of general interpretation of the agreed statement, which I mentioned, which is attached with the Article 10, certain limitations of the WIPO copyright treaty, which explains that these exceptions limitations can be extended to the digital environment. Not only that, new exceptions and limitations can be introduced by the member states. So how it is legal? Because Article 31, paragraph 2A Para A of the Vienna Convention of Law of Treaty in 1967 says when you are reading the treaty and interpreting a treaty, not only you interpret together, the harmonious reading has to happen, harmonious reading of the entire article, the preamble, paragraphs, sentences, legal sentences provided in the preamble. And then comes the articles, then comes the agreed statement. So agreed statement has the equal legal value of the article to which it belongs. So it simply says so. That allows the new exceptions, limitations, extending the physical environment copyright exception limitations to the digital environment, and also introducing new, devising new limitation exception, which we have done while drafting the physically impaired and visually impaired persons provisions like section 52 1 ZB. So we said adaptation and the use of special format copies for the blind people. This is possible that such adaptation can be done from physical copies to the readable, machine readable copies for the blind, even though commercial copies are available in the market, because that may be expensive and the poor blind student may not be getting access because of the high price special format copies. Still, such copies can be made either be next of the kin of these people or any NGO. Using the compulsory license mechanism, they can do that. So this kind of new exceptions we devise to help the blind people. So this is possible because of these provisions in the international treaties help India to draft such legislations to help the blind people. We have not only drafted these things, again we took it to the when international treaty for the copyright exceptions for the blind and visually impaired was being negotiated through the diplomatic conference and being finalized in Marrakesh in 2013. We inserted Indian legal tools and Indian legal language in the Marrakesh Treaty successfully. And not only that, anything Marrakesh Plus, the Indian provisions which are more than Marrakesh Treaty are there. For example, audio description of video content. So the US did not allow such things to be that they wanted Marrakesh Treaty copyright exception to the blind only to the books, not to the videos and films. But Indian laws provides that copyright exception for videos and films also. So how this happens when a blind man watching a video or a film, so he can't see. So for a deaf and dumb, there is a sign language is there. For the blind, there is the audio description comes. For instance, there is a pause during the film, only music is coming and the characters are moving in a room. So the description comes and explains how the characters are looking, what is this nature, and what kind of clothes are they wearing, and everything is explained, and what is the atmosphere in the room or what is the atmosphere outside the room. All these things are explained through audio description. So audio description is a technology, a descriptive technology, makes blind to understand, not only hear the dialogue or hear the music and visualize the how character looks like, the hero looks like, or heroine looks like, or other characters of the film look like, or in which locations the film has been shot, whether it is outside or within the studio. All these things are explained to them. So and Australia started the audio description broadcasting for the blinds, just like we have deaf and dumb news broadcast. And India has taken a decision, the Information Broadcasting Ministry recently, that they will be introducing audio description broadcast for the blind. Hopefully, few old films, copyright expired films, like Indian classics and various Indian film division documentaries and various classroom teaching videos, of science communication videos maybe audio described and made available to the blind students so that they can watch this and proudly say, "मैंने film देखा." I've seen the film. Oh, this is going to happen soon. So here I stop, my friends. I finished my talk. You can ask questions. Thank you again, Dr. Manish, Professor Bhatnagar, and Dr. Bhati for
ये बंद हो गई क्या? खत्म हो गई है? और ये तो वो हो गया, चले गए, कोई दिक्कत
सर
नहीं, अभी आ रहे हैं थोड़ा।
kindly mute your mic, everyone. Sir, you had covered all the areas which we were talking about. And importantly, you had highlighted how technology is posing a challenge for the law. And it's often seen that law is lagging behind technology. Sometimes we look for the solutions beyond the law itself. So, for example, encryption technology, such as you had very beautifully covered all the international treaties, the provisions, the DRM provisions, which have been adopted in India in the form of Section 65 Capital A and 65 Capital B. And then, when you had spoken about the deal for the copy case, which was very contemporary of relevance for all the participants. All the participants, and it would be helpful for them. So there are 2-3 questions that had came up. One of the question is how the data like video, audio, PDF or document files are to be checked if they are pirated or not pirated. Say for example, on the YouTube, and someone shares it unknowingly, be a pirated copy, or he gets it from some other online digital thing. Is there any method to check?
So obviously, the content is pirated. So the various devices are there to identify, and it is not downloaded legally. And once it is downloaded after payment of premium, the person who has downloaded is not supposed to circulate it. So it is a pirated copy. Though you have a right to purchase, once you have purchased, right to use for yourself only, not circulating it to others. So access bought a ebook in a PDF form, and he read it and used it and passed it to Y. That is illegal. Simple. Because Y has not downloaded and purchased from the legal website.
Another question that has came was how this online digital platform is touching upon the issues of privacy, and whether privacy has something to do with the IP law, specifically copyright.
Can you repeat the question?
There are some regarding the privacy of data.
Okay.
And that data being shared online by someone else. Whether the copyright law deals with it. That was one of the questions that we had.
So, for instance, digital platform uploading the content, the platform owner has to make sure whether he has the copyright for that content. So it means either the author or the right owner has to upload that, not the third party. Third party is not supposed to upload that. And then if any privacy issues that comes because the person who has uploaded has not created that content, the content creator or content owner himself responsible for the issues related to privacy. For instance, he made a film based on the biography of a celebrity. So he is responsible, but not the person who has unauthorizedly uploaded it. So the person who made a film should have taken permission to make such biography of that person and derivative work out of that. And then comes the issue of user generated content. For example, you yourself, phone or a video equipment to make a film and then upload it. If there is a issue of privacy into that, so you should have taken permission of some people which you are not done that. They're objecting to that, then means that video has to be taken down because otherwise, it may be a infringement of their privacy. Yeah.
So there's one more question. When we emphasize upon, when we emphasize upon,
I can't hear you.
right, so when we emphasize upon more robust protection to the copyright in India, and most of the business are not based here; they're primarily outside this country. So how that is in benefit for a developing country like us. So for
Your
example,
voice is breaking because your voice is breaking. It's not clearly audible.
okay, so I will try once. My question was when most of the online business models are situated and are run from outside India, say for example Netflix or Amazon, then why being a developing country
I can't hear.
all right, sir. I would take up one last question. Sir, the last question would be how effective.
Is that about uh, content provider from abroad you are asking about, like Netflix?
My question was that these people are not based in India. Their business is not based here. They are consumer based here.
Yeah.
So why should, as a developing nation, we should be overprotected about copyright?
Okay. It's a not copyright. It's a business model. It's a platform. You, any platform by a foreign person and it is being served from the abroad, server is abroad, but Indian content is made available that it is made available legally. For example, you take Netflix, it is a foreign from, let's say, any other EU or US, the content, Indian content, it's uploaded there for watch, it is the right owners, the film producers, filmmakers, content makers are having advertised, understanding and MOU with them, a business model agreement with them, and then sharing the revenues. So it does become very popular. If any other popular similar platform, content streaming platform created by an Indian, made available from India, why can't that become popular? It all depends on the what kind of content you are providing, whether it is a watchable or interesting or entertaining or imparting a knowledge. It all depends on the taste and the favor and interest of the people who are watching and streaming those video content made available.
So the last question will be What is the effectiveness of these DRM provisions? How far, in practical terms, can they be enforced? Do companies have that kind of structure that they can bring a criminal suit against all the violators of the DRM provisions? Is it
So,
practical?
best example of DRM is the lockdown period, and most of more than 200 people are watching this talk. 80 to 90% of the viewing to streaming content from Netflix or Hotstar or any other streaming website. And all these streaming websites are successful in protecting the content because of the DRM provisions of in the WCT WPPT, which we adopted and implemented in section 65A and 65B. Number two, and in the physical environment before the lockdown, maybe after the lockdown also, when multiplex theaters are open, the films are shown there with the using DRM devices, you know, various devices like fingerprinting, watermark to stem the piracy. And these are all being successful. And then couple of Delhi High Court judgments also supporting this, and people successfully protecting their content, raising the provisions of 65A and 65B. I don't remember, and otherwise I would have given the citation of those two cases as well.
Thank you, sir, for answering all the queries which had come up during your session. I would like to extend to first of all of our Vice Chancellor Dr. Subir Kumar Bhatnagar, the Chief Patron of the program, his constant encouragement and guidance that make this program successful. Secondly, I wish to extend my deepest gratitude and thanks to you, sir, for accepting the invitation despite your busy schedule and readily agreeing in the sense for the benefit of academia to share your insights and knowledge with us. Thank you, sir, on behalf of the university, organizing committee, and participants. And we hope that we will be enlightened in the future as well from your wisdom. Thank you, sir.
Yeah, yeah. Thank you, Dr. Vikas, for inviting me. Finally, you conspired to bring me here to RMLNLU, because a couple of occasions I was invited. I couldn't come to your university, law school. Finally, it is happening today during this lockdown period of COVID pandemic. And I'm able to come to you over this webinar and give my thoughts, and then share my knowledge, whatever I know about copyright law at national and international level. And I would like to thank Dr. Manish and also Professor Bhatnagar, who is a good friend of mine. And wish you all the best. Stay safe and take care. And namaskar to all the participants. Wish you all the best.
I would also take this opportunity to thank our very own Associate Professor Dr. Manish Singh for being the program director of the same, the webinar. And he also has been a constant source of encouragement for all of us and been instrumental in the organization of this webinar. Also, I would like to extend my heartfelt gratitude to Shri Diwakar Sarji, the Joint Registrar Dr. Ramanath National Law University, who helped us out through the nitty-gritties of organizing a webinar in a technological environment. We were not trained in all this in such a manner. He helped us out and we also helped us out in outreaching to the maximum number of the participants. I would also like to thank Mr. Uh, Abhinav Sharma, office assistant, who untiringly had created all the database and communicated with all the participants, and has also been played an important role in organization of this program. Last but not the least, uh, I extend my heartfelt thank to all the participants of the program who very keen took interest in this and quite attentively listened to the distinguished speaker, Sri Raghavendra. Thank you, one and all. Wish you health, stay safe from COVID-19, maintain physical distancing, social distance. Thank you.
बंद करें बंद करें मीटिंग ठीक है लीव करें ठीक
So that was all. We hope to see you soon and come up with a new relevant contemporary discussion subject matter and would definitely invite you for this. Thank you, everyone.
डिफॉल्टर के अंदर डॉक्यूमेंट के अंदर रिकॉर्डिंग हुई है हाँ नहीं चैट की रिकॉर्डिंग कितने बार प्रेजेंटेशन की भी रिकॉर्डिंग होगी क्या